One of the things about the law business, the legal industry, is some of the most important things about law are actually so simple that they're easy to overlook. And there are only about 4 very simple truths. And if you know and understand these truths, you will be empowered to win. Here's the first great secret. Where does the court get its jurisdiction? We have a 2-tiered court system. There are the Supreme Courts and their tribunals. There are courts of inferior jurisdiction. When we're talking about Supreme Courts, like the United States Supreme Court and the Oklahoma Supreme Court, where do they get their jurisdiction? They get their jurisdiction because of who they are. But what about these courts of inferior jurisdiction? Where do they get their authority? The courts of inferior jurisdiction are empowered to act by pleadings sufficient to invoke their judicial authority, which means that the people, not the attorneys, the people that walk into that court empower that person in a black robe to be a judge.
Listen closely to what this guy just said. It is earth-shaking and game-changing. It puts the ball in your hands. What is he saying exactly? An injured human being has to show up in court and testify under oath that they have been injured, period. Prosecuting attorneys testify like they are the injured party, and they are not the injured party. They don't get to testify because they are not the ones injured, but they do it all the time because no one puts them in their place. Trinzi versus Pagliaro states statements of counsel in brief or an argument are not sufficient for summary judgment. If the judge doesn't like it, it's too bad. The Supreme Court, this is a Supreme Court ruling, and basically what it's saying is to the lawyer, shut up and sit down, you don't get to testify.
Jurisdiction has 4 corners on it. It's a 4-legged table. And if you take away one of those legs, it's not a court anymore. You win when you know how to invoke the court's jurisdiction, when you empower that judge to make the decision that you want that judge to make. That's the second great secret, is the Constitution, state constitutions, statutes, laws, rules. What meaning do they have as you read them in their black and white print? They don't really mean anything except a hint, a suggestion of what the law is. Well, we have a common law system. The Supreme Court tells you what that means. To find out what the law is, we have to find out what the Supreme Courts have said that that particular law means. Now, that's the second great secret. We have a means of finding out what the law is. It's written down. Where do we find the common law? It's the federal and state annotated statutes. Because, again, that's a secret. They don't want you to know that. If you can read the annotated statutes, now you know what the law is. The state annotated statutes. Those annotated statutes are going to tell me what the law is. But they're going to publish the holding. They're going to tell you the essence of that decision. And that essence of that decision, out of that case, is that one paragraph, that one sentence, or maybe just that one phrase that you need to win, and that's all you need. Trinzi versus Pagliaro is one of the most important cases that has ever been decided by the United States Supreme Court. But Trinzi versus Pagliaro is absolutely earth-shaking. The holding of Trinzi versus Pagliaro, statements of counsel in brief or argument are not sufficient for a summary judgment. Take it to heart, memorize it, get a tattoo that says that. Because that is one of the most important principles in law. And that is one of the most powerful things that you will ever learn and have to use. That's according to the United States Supreme Court. But that one-fourth thing that has probably been missing 50 million times in this country when we got shafted in the court was a competent witness. Where's the competent witness? That's the fourth leg on that table. That table doesn't have four legs. That court did not have jurisdiction. Period. You've got to have somebody at some point in time before the judgment raise their hand and testify under oath and subject to cross-examination, or it's nonsense. If the other side supports their pleadings with an affidavit, which they rarely do, but if they do, you subpoena that witness because you want to question him under oath. And the idea that is the kernel of truth in Trenzi versus Pagliaro is a thread that runs through everything. Criminal, civil, it runs through everything. Administrative, it's got to be there. It's got to be there. How do I know? Here is a very good statement. And again, this is from an annotated statute. Actual facts, not mere allegations of complaint, are determinative of issue of jurisdiction. Isn't that what I just said? If there's no witness, there's no facts. If there's no facts, there's no what? No jurisdiction. That's not what I think. I think it, but it's not true because I think it. It's true because it's the law. It's the law because the Supreme Court says yes, you've got to have a competent witness to have that fourth leg on that table, or there's no jurisdiction.
So you get into a courtroom, you're sitting in court, and the prosecuting attorney stands up and he says, Mr. Johnson was caught urinating on the next door neighbor's pet. You stand up and you say, if you're Mr. Johnson, you stand up and you say, I object, Your Honor. Trenzi versus Pagliaro. Statements of counsel in brief or an argument are not sufficient for summary judgment. See, the lawyer wasn't there. He doesn't know. He didn't see you piss on the neighbor's dog. He don't know what he's talking about. It's all hearsay. So you stand up and you object, and you do this 3 times. And on the third time, if the judge doesn't catch on, you take exception to it. And then later on in the course of the legal proceedings, you bring it back to that, and it'll get tossed out. There's no doubt about it. It's a slam dunk case. This isn't my opinion. This is Supreme Court rulings. This is the most powerful thing you could ever think of. And here's the thing. It does not matter what you are in court for. It doesn't matter if you're in a criminal court. It doesn't matter if you're in a civil court. It doesn't matter if you're getting sued for money or if you're getting sued for murder, or if you're getting sued. It doesn't matter what it's for. You have to have a competent witness stand up and testify and say you injured him. The lawyer doesn't get to do it. In another case, a lawyer might get up and say, Mr. Flintstone stole 72 cases of paper clips, and he's just reading from his paper there. That's when you stand up and you say, objection, Your Honor, statements of counsel in brief or an argument are not sufficient for summary judgment. It's that freaking simple. The guy's got to sit down. He does not get to get up there and talk negatively about you. He don't know you. He doesn't get up there and get to say what an evil person you are because he has no first-hand knowledge. You can read it out of it's like he's reading it out of the daily newspaper. He's an idiot. And it's your job, if you want your freedom, to stand up to him and say, I object, and state Trenzi versus Pagliaro. It's that simple, folks.